bring in Fox News senior judicial analyst Judge Andrew Napolitano right now. Judge, these are very strong accusations. Your thoughts?
Well, they're most likely true. I mean, think of this as a three-step process. Surveillance, which is the acquisition in a digital version of every keystroke on every computer and every communication on every cell phone and landline phone. Storage, which is the maintenance of the digital version of these communications. And then unmasking, which is accessing this data and finding out the names of the people who were actually surveilled. So it is beyond dispute that the NSA has access to, if it wants, it would be unlawful for them to do this, but they have it, every phone call of every person in the United States of America since 2005. Takes us back to a Republican administration, George W. Bush, 2005, which is when this program began. Justice Scalia told me he often thought that the court was being surveilled. And he told me that probably about 4 or 5 years ago. Again, surveillance, acquisition of information, unmasking, accessing information.
Well, I mean, step one and the surveillance is, I mean, why would the Obama administration, well, using government resources to spy on anybody running against Hillary Clinton? I mean, that is just wrong.
Well, it is you're exactly correct. It is the use to which the raw intelligence data can be put that makes it criminal. So if it's hard to believe, but if they had to unmask Senator Paul's name in order to understand a conversation he was having with a foreign agent, and the foreign agent was harmful to the United States, they can do that. That's not what he's talking about. They're talking about unmasking him when he's having a conversation with his campaign manager when he's running in the Republican primaries in 2016.
Exactly. Let's just be clear. This is two different things. The unmasking of Michael Flynn and the spying there is completely separate and apart from what Rand Paul is talking about. He's talking about running for president in the fall of 2016. He was surveilled, spied on by the Obama administration.
Actually, the unmasking of General Flynn might be a species of the same thing, because a lot of people believe, the president among them, that General Flynn was unmasked for political reasons. That is, portions of his conversation with Ambassador Kislyak were revealed in order to embarrass the president, embarrass General Flynn, and force the president to separate himself from General Flynn. But let me make an absolute statement. There are very few absolutes in law. The use of intelligence data for political purposes is a felony. It's the same crime as hacking, which, depending upon how much is done, is between 5 and 15 years in a federal prison.
So if another senator comes forward with this same story, I was surveilled, could President Obama be called to testify on this?
Well, anybody who was involved in the receipt or use of the information once unmasked could be called.
Go ahead,
the FBI should be able, because you leave electronic fingerprints when you do unmasking, find out who did the unmasking in Senator Paul's case, and then trace where that information went and who used it. Did it end up in the West Wing? Did it end up in the Oval Office? Did it end up in the hands of other political opponents of him?
So they're allowed to gather it. They're just not allowed to use it for political purposes.
Well,
I don't think they're allowed to gather it.
They're not allowed to gather it, but they do, because their belief is to gather everything about everybody and then sift through and look for the bad people. Unfortunately, sometimes they find the bad people too late. I mean, they discovered communications of the Orlando killer and the San Bernardino killers after the killings took place. I have often argued, and a lot of people with me, and a lot of people disagree with me, that it's too much information. It's information overload. If you follow the Fourth Amendment, you not only leave innocent people alone, you are forced to focus on people as to whom there is a suspicion of wrongdoing.
So, Judge, I have a question. Under FISA, Foreign Intelligence Surveillance Act, it is legal for the government to surveil Ambassador Kislyak or foreign agents who might be in the U.S. or impacting the U.S. So it's not unreasonable that when Senator Rand Paul or others run for president and they're speaking to these ambassadors, they're speaking to these diplomats, they are involved they're swept up in the surveillance.
It's a good place to hide behind anyway.
So you have that, but you also have
the unmasking of Senator Paul and the using of what he said. Let's assume he spoke to Kislyak. I don't know. I think he's talking about a conversation that is a private political conversation and has nothing to do with foreign powers.
Yeah, that's exactly right. This has nothing to do with the Russia story.
It is the release of that information for political purposes, whether it's made public or not, or whether his opponents just used it, that is the felony.
So just to be clear, the unmasking itself itself is not illegal. Using the name that was unmasked for political purposes
Unmasking is illegal if done for any reason other than national security.
Got it.
So if the unmasking is done for political purposes,
so Judge, the unmasking
crime.
process, does the FBI, do they have to go to a judge and get permission for that unmasking, or they have completely the right to do it on their own and then find criminal intent?
The NSA theoretically has standards for unmasking. The principal unmasker in the Obama administration, by her own acknowledgement, is Susan Rice. So Susan Rice would say to the NSA, we have these 5 conversations here, we need them unmasked. We know who the foreign agent is, we don't know who the Americans are. And by the way, there is an American mentioned in the conversation. We need the tapes that you have of that person and his or her conversation. So you can see how this begins to explode. It's the corruption of the American intelligence community when its information is used for political purposes.
Well, we'll see if Bernie Sanders or Marco Rubio or somebody else comes out and says they were also spied on, the way Rand Paul said that he was spied on, and we'll see what happens from there. We want to ask you about the executive order, which, of course, is halting travel from 6 predominantly Muslim nations. The Ninth Circuit Court of Appeals is set to hear oral arguments today, stemming from the Hawaii judge's order to block the order. The 3 judges, all Democrats, appointed by President Clinton. What is the significance of today's hearing? Okay,
so last Monday we had a hearing in Richmond. The Fourth Circuit Court of Appeals heard oral argument on the appeal of a decision by a federal judge in Maryland to stay the portion of the executive order that blocked immigration from 6 countries. Today we will hear in Seattle a hearing before the Ninth Circuit Court of Appeals on an appeal from a Hawaii federal judge who enjoined enforcement of the entire order. Both federal district court orders were based on the same thing: the words of candidate Trump and his animosity, I'm summarizing what the court said, towards Muslims. They both characterize this not as an immigration ban, but as a Muslim ban. Yep. If it is a Muslim ban, if it is based on religion, the bar is so high it would be nearly impossible for the government to jump over that bar and justify it. So the question is, can the courts use the words of candidate Trump against President Trump? I'm sorry to say the answer is yes. The Supreme Court doesn't like when this is done, but it permits the courts to do it.
Wow. All right. We'll be watching that. Judge, great insights as always. Thank you.
Pleasure, guys.
Judge Napolitano there.